Having had the benefit of reading the draft and the revised opinions circulated by the learned Chief Justice, we find it necessary to pen our reasoning and conclusions in this separate judgment. The learned Chief Justice has recorded in detail the submissions by counsel and claims made. They therefore do not require iteration. Similarly, the sections addressing the Union government's preliminary objections, that is, the discussion on the court's authority to hear the case and that queerness is a natural phenomenon that is neither urban nor elite, are parts we have no hesitation in agreeing with. However, we do not agree with the conclusions arrived by the learned Chief Justice and the directions issued. We do not agree with certain premises and conclusions that he has recorded. They are: one, that there exists no fundamental. We do agree with the premises and conclusions that he has recorded. They are that there exists no fundamental right to marry under the Constitution, that the Special Marriage Act is neither unconstitutional nor can it be interpreted in such a manner as to enable marriage between queer persons, and that transgender persons in heterosexual relationships have the right to solemnize marriage under the existing legal frameworks. We have briefly highlighted our main points of agreement and reasoned in more detail those aspects with which respectfully we cannot persuade ourselves to concur. We had the benefit of perusing the concurring opinion of Justice Narasimha. We endorse those observations and conclusions fully. The reasoning and conclusions shall be read as supplementing that of the present judgment. For long periods in societies, many societies, the choice of a matrimonial was not free. It was bound by social constraints. Much of the time, marriage was seen as an institution meant for procreation and sexual union of spouses. In most societies, marriage had cast roles for the spouse. They were fairly inflexible, with men controlling most decisions and women placed in a subordinate position with little or no voice, and for the longest time, no legal authority, autonomy, or agency. For millennia, custom, tradition, and law subordinated wives to husbands. Notions of equality of partners or their roles were uncommon, if not totally unheard of. All these underwent radical change. Legislative activity is aimed at bringing about gender parity through prohibiting prevailing practices that further inequality and sometimes even criminalize certain customs, resulting in legislations such as Equal Remuneration Act, the Dowry Prohibition Act, introduction of provisions in the criminal law which gave teeth to such provisions, such as Section 498, Section 113 A and B of the Evidence Act, etc. Other practices aimed at realization of social goals and furthering the mandate of Article 15(3) in respect of children, such as the right to free universal education under Article 21A, the Right to Free Education under Act 2009, the Child Labor Prohibition and Regulation Act 1986, the POCSO, what we call as POCSO, the Juvenile Justice Act, etc. In all these, the Parliament or concerned legislatures donned the role of reformers and furthered the express provisions of the Constitution, enjoining state action in furtherance of Articles 15(2), 15(3), 17, 23, and 24. Marriage has historically been a union solemnized as per customs, a personal law tracing its origin to religious texts. Legislative activity in the personal law field so far has been largely, though not wholly, to codify prevailing customs and traditions and regulating them only where needed. The instances that stand out are the enactment of the Succession Act, the Hindu Women's Right to Property Act, 1937, the Hindu Marriage Act, the Adoptions and Maintenance Act, the Hindu Succession Act, the Hindu Minority and Guardianship Act, and the Indian Divorce Act. As amended, the Muslim Personal Law Sharia Application Act and the Anand Marriage Act, 1909. These laws mostly codified traditions and customs which existed, and also, to an extent, regulated marriages and succession laws. They also sought to introduce reforms. For the first time, monogamy was enacted as a norm applicable to all Hindus. Likewise, the option of divorce was enacted together with grounds on which other remedies such as judicial separation and maintenance could be sought. Further, the minimum age of marriage was also enacted through provisions in various personal laws and enforced through the Prohibition of Child Marriage Act. Thus seen that two kinds of legislations have regulated marriage. The first, like SMA, HMA, the Hindu Disabilities Removal Act and the Hindu Widows Remarriage Act removed barriers and enabled exercise of meaningful choice, especially to women. The second kind of laws are those which enacted restrictive guidelines, essentially to further an orderly society or to protect women, define minimum age for marriage, child marriage restraint, marriage of individuals within prohibited degrees of relationships, etc. Whereas some restrictions, in a sense, codified and recognized existing customs, such as being enacted by enacting prohibited degrees of relationships, the rule against insanity, rules enabling declaration of nullity or divorce on ground others were meant to further interests of women and children. Such reforming and codification, however, did not cover the entire field. For instance, in the field of succession and inheritance, the Hindu Succession Act enacts only certain broad features, leaving untouched the rights of various communities and sections of Hindus to work out their rights in succession, the joint family, and co-parcenary property. And this unwritten codified law is enforced not only in regard to inheritance, but also in the field of taxation. Likewise, the law accommodates and accords primacy to customs. Similarly, also recognizes customary divorce amongst Hindus. Neither the Hindu Marriage Act nor the Hindu Succession Act apply to members of tribal communities. In the latest three-judge bench decision in Revana Siddhappa versus Mallikarjuna, this court clarified that with the enactment of Section 16 of HMA, the legitimacy conferred upon children born of void or voidable marriages would be that they are entitled only to a share in their parents' property, but cannot claim it of their own right, as a consequence of which they cannot seek partition during the lifetime of their parents. The court also held that they cannot claim any rights other than what was expressly provided for. Thus, uncodified law and custom was upheld. The role of the legislature has been to act as a codifier and in many instances not enact or codify existing customs or practices, and wherever necessary intervene in furtherance of Articles 14 and 15(3) to enact laws. Parliament has intervened and facilitated creation of social status, this is marriage through SMA, and enabled the creation of the institution of adoption, which was available amongst only certain communities. These and other legislative interventions are the result of the state interest in reforms or furthering the interests of given communities or persons. For these reasons, we do not particularly subscribe to the characterization of democratizing intimate zones as discussed in the learned Chief Justice's opinion. These outcomes were driven by enacted law. Furthermore, there was state interest which impelled regulation of such relationships, as for instance, ensuring that minimum marriage age for girls. Likewise, there is state interest in regulating what kind of relationships, that is, prohibited degrees of relationship, should be enacted as disqualifications to marriage. Then there is a discussion or summation of the jurisprudence on Article 21 and the various facets which this court has recognized, such as privacy, choice, autonomy, and dignity. Then we move on. The court's intervention in oft-cited decisions on behalf of the petitioners has been to protect citizens or those approaching them against threats of violence. The instances are Shakti Vahini, Lata Singh, Shafin Jahan, Lakshmi Bai Chandragi, etc. These decisions were based on the state's duty to protect citizens and enable the exercise of their individual choice in the face of threats. Other decisions, that is Joseph Shine, Uptage, and Independent Thought, were instances where specific provisions that criminalized or made exceptions to criminal behavior were struck down or read down in the enforcement of fundamental rights. That is Articles 14, 15, and 21. Along the way, Puttaswamy articulated the broadest right to privacy, which embraces within its fold the right to exercise one's choice of a life partner and to lead the life free from external barriers. This court has recognized that marriage is a social institution. As elaborated in Part 1, marriage existed and exists historically and chronologically in all of the senses because people married before the rise of the state as a concept. Therefore, marriage as an institution is prior to the state, it precedes it. The status is still not one that is conferred by the state, unlike the license regime in the US. This implies that the marriage structure exists regardless of the state, which can later utilize or accommodate but cannot abolish it. Under this view, terms of a marriage are set to a large extent independently of the state. Its source is external. That source defines the boundaries of marriage. This implies that state power to regulate marriage does not sit easy with the idea of marriage as a fundamental right. In attempting to analyze the claim to fundamental right, there are two primarily competing claims about the nature of marriage. One being that the state should exercise more control over marriage to support traditional purposes and perceptions. This is the quotation. And the other, that each individual should have the right to define marriage for themselves. If indeed there is a right to marry, unless it is elevated to a right akin to Articles 17, 23, and 24, which apply to both state and non-state agencies, and are cast in positive, in fact, emphatic terms, it cannot be operationalized. These provisions most emphatically create positive obligations. Likewise, Articles 15.3, 15.4, 15.6, as well as 16.4, 16.6 highlight state interest in creating conditions to further the goal of non-discrimination. Yet the previous decisions of this court have carefully held such provisions to enable the state and in the sense oblige it to take measures, but ruled out court-mandated policies and laws. In our considered opinion, this is not, however, one such case where the court can make a departure from such a rule and require the state to create social or legal status.